first matter today is State of Ohio versus Jarvis. And as you know, each side will have 15 minutes, and the appellant is reserved up to 5 minutes for rebuttal, so please let me know if you wish that time to be reserved. And I need to remind everyone that we should be using the front lectern rather than the other, but my colleague corrected me the last hearing day, and I appreciate the help. Thank you. You may begin.
Attorney Nicholas Hannick representing the appellant. I'd like to reserve 2 minutes, 2 minutes for rebuttal if necessary.
Thank you.
May it please the court. The issue in this case is much to do with the definitions of what and how it fits what happened in this case. There is no way to say that he did not commit crimes in this matter. The question is whether or not it meets the definition, specifically the definitions as far as the 2 kidnapping counts, very much on the issue of substantial risk and in serious physical harm. What happens in this case, I think the facts that are pretty clear that to some extent looking at is that he has her in the car is moving, he strikes her 2 times. There is no allegation that those strikes were of such a nature that they would themselves cause a serious physical harm. Following that, she jumps out of the car. The question becomes, as far as the kidnapping counts, and this is the same as whenever you're looking at the B section of the statute, whether it be under count 1 or count 2. Does those conditions create a substantial risk of a situation to cause serious physical harm? Now, could this be a situation that causes a risk of harm? Sure. Does it get to the point where it is a substantial risk, or looking at it as the both the court's instructions and as we're required to do, is a strong possibility of this? This is not an allegation where he pushed her out of a car door. It's not an allegation where a weapon forced her out. It's that he struck her. The question becomes, there are a lot of times, and there are many, many, many cases that domestic violence and or simple assault occur in cars. And one of the reasons that is that there are usually more people around. And so a lot of times they're called in. It's rare to see one of those cases turn into or it's every one of those situations where domestic violence or simple assault occurs in a car, a situation where there is a substantial risk of serious physical harm.
Are you suggesting that in those cases involve someone attempting to flee from the vehicle in order to save their lives?
I'm not suggesting that, but I would differentiate this situation. I don't believe this situation, it arises to that level of situation where she's attempting to flee to save her life. I'm saying that in these other cases, if somebody were to get out of the car and suffer an injury in any other fact pattern, are we going to turn everything into a car, into a kidnapping and or felonious assault scenario?
Well, the kidnapping, it seems to me, that's not really what we're arguing about. Are we arguing about the elements of kidnapping, that whether he restrained her, or whether as you began your argument was, you said the issue is whether the evidence establishes substantial risk or serious physical harm. So if we just isolate that, it seems to me that we're not necessarily talking about the fact that he struck her and whether or not that met the standard of substantial risk or serious physical harm, but the fact that she, while attempting to escape, had or was caused serious physical harm or substantial risk. And in order to look at that, it seems to me that we have to look at the totality of the circumstances, the evidence that was put on by the state, she said to him multiple times, let me out, let me out, let me out, that he passed by her car and, was headed in a dark area. If her testimony was to be believed, that she didn't think she was going to make it out of there. So escape, do you escape or do you just wait to see what happens?
What I would say that and I agree with you that this is looking at a totality, and I agree with you that it's looking at this not just as far as the physical strikes are concerned. I agree with that entirely. I'm saying that I think, does it arise, is there a risk? Yes. Does it arise to substantial? And does it arise to substantial risk of serious physical harm? Is there a risk of something bad happening to her at that point? Sure.
What kind of vehicle, do we know what kind of vehicle, was this a car or a truck?
It's a truck.
Okay, so that would suggest, and I don't know if there was any testimony about this, because I haven't read the record yet, what kind of truck, how high off the ground it was, but those are things I think that the fact finder could take into consideration, that it may be different jumping out of a truck versus jumping out of a car. The other aspect is, I'm not sure whether the testimony establishes the speed at which the truck was moving at the time. Do we know that?
I'd have to double check and look, but I believe it was not, this was not a situation where it was going at a beyond the speed limit. It was 20, I think it was about 25 miles an hour. I do not have that offhand, but it is my recollection that was not it was not at a speed at which they said this is it's not going 100 miles an hour, it's not that sort of thing.
Well, let's just assume the speed limit was 25 miles an hour, and you jump out of a truck that's moving at 25 miles an hour onto pavement, presumably onto pavement. That sounds like substantial risk to me.
But I think what I'm asking the court to consider is, sure, her jumping out of that truck is certainly a situation that is very risky for her. Did he create that situation where she had to do that? I think this is akin to a situation where this is a simple assault on unlawful restraint rather than a kidnapping and a felonious. That's what it boils down to here. That's what I'm boiling down to. See, did he create that situation? It's hard to differentiate. It's hard to have a discussion because of how these are not very positive facts for Mr. Jarvis and looking at it. But the question is, did he hit the definitions of what it takes to get to the substantial risk and the serious physical harm? And there also ties into that with the felonious assault. I wanted to address the felonious assault count. The argument applies to whether he knowingly created any serious physical harm. And knowingly meaning that he was aware that that was even a possibility from those circumstances.
When the agreement was she agreed for him to, people didn't even know each other before this event, right? And the agreement was that he would take her to her car, right?
Yes.
And then he went way past her car.
And what happened, what it appears, there's multiple versions of what she said.
But in any event, he didn't take her to the car, that was the agreement, right?
Correct.
And then he didn't take her there.
No.
Okay.
No, I mean, but then she got out of you let her out of the car, and she got back into the car, and then
he promised to take her to her car then?
It's tough to tell from the state of Ohio's witness because she has a couple different versions. I can say, I know they're in the car at least twice, and that she's testified that he was going to take in the car and then he did not. I mean, I would agree with that. That part of the kidnapping count, I'm not saying that the deception or anything, I'm not saying that part wasn't there. I'm solely looking at whether this was a situation that created the substantial risk of serious physical harm for her.
Well, if he had taken her to her car and dropped her off, like he was supposed to do in the first place, that was the agreement, nothing else would have happened, right?
It's true, and then he could have committed unlawful restraint, and a simple assault. This would be my argument.
Well, what about the fact that she testified that after she jumped out of the truck, that he put it in reverse and ran into her, injuring her shoulder? That standing alone may be sufficient.
There was, there is that, there is an element. She testified that the truck hit her. She flew into the air a few feet, and then she got up and ran away.
Well, he didn't dispute that, at least in his interview to the police officer. He testified that he backed up and that he might have hit her.
I think the issue about possibly the truck did not come up on the scene was something that came up later on. It wasn't something that she stated on that night. It wasn't something that they maybe were dealing with. I would, if that were to be believed, it still has to be an element of, there has to be knowingly, there has to be something that he did to intentionally, willfully do that act, and I'm not sure that could be met. And I think that it's very difficult. I think it tests logic and reason. That she said she flew into the air and then she ran and no one saw. And, I mean, if you accept that she jumps out of the car and then she did not sustain injury from that, and then she was to get in, have a shoulder injury from a car hitting her later, it's more likely that falling onto a shoulder from the jump from the car. I mean, to have a truck hit you and suffer no injury would be.
But there's no dispute that he backed up towards her.
I would argue that there is a dispute on that. I don't think he ever directly said, I backed up the car towards her and hit her.
I thought her testimony was that he hit her in the same shoulder that she landed on when she flew out of the truck.
I would say that is true. She did say that. However, it would be.
So how do you know which damage was caused by her falling out of the truck or getting hit by the truck? No, they go, why didn't he stop the truck and run around back and see, hey, how you doing? That didn't happen. He backed up and hit her with the truck.
That would be, well, that's what was, that's what she alleged had happened, ultimately not at the scene, but later on, and said that she flew in the air and got up and ran.
And that's what the trial court found.
What's that?
That's one of the findings of fact the trial court found.
It's possible. I mean, they did find on that. There's a lot. So your question is, you're asking. Sorry, I want to.
I get the bottom line. It's my understanding that when she fell out of the truck, she landed on her shoulder, or jumped out of the truck, she landed on her shoulder. And then I thought that I read that when the truck hit her, it also hit her in the same shoulder that she jumped out of the truck and landed on. So it'd be hard to tell whether she got hurt from landing on the shoulder or getting hit by the truck in the same shoulder. Who knows which injury came from which? It all happened in the same few minutes.
You're closing in on your 2 minutes.
Okay, thank you. I
I
will.
didn't mean to cut you off.
That's
okay.
okay.
No,
I'll reserve my time for a while. Thank you.
May it please the court, my name is Natasha Guerreri and I represent the appellee of the state of Ohio in this matter. I guess first just to go straight to the kidnapping and the substantial risk of serious physical harm. The state would point to this court to the 8th District Court of Appeals decision State versus Jackson. In that case, the court found that an accused is presumed to intend the natural, reasonable, and probable consequences of his acts. And in that case, that was in reference to a kidnapping case, and they found that one of the consequences of the defendant in that case holding the victim at gunpoint is possible escape or an attempt at an escape. And there, that the injuries suffered as a result of the escape could in fact be considered when dealing with a substantial risk or reviewing the issue of substantial risk of physical harm. Here we have the victim, Ms. Anderson, testifying that she did in fact agree to go with Mr. Jarvis in his vehicle so that she can return, he can take her back to her vehicle. They went in that direction, but he passed it up, and she repeatedly asked him, are you going to take me to my car? We passed it up. Where are we going? Are you going to take me back to my car? He wasn't responding the entire time during that time while in the vehicle. And then at some point, they were at a light. She decided she was going to jump out of the vehicle at that point and just walk back to her car. Then Mr. Jarvis came back, said, I apologize basically, I was a jerk, I'll take you back to your car. She felt it was sincere at that point. She got back in, and instead of walking those several miles back to her car in the cold, decided, okay, I'll go back. He seemed sincere. And once she got back in the vehicle, he proceeded in the same direction that he was going in. Again, she started questioning him, why aren't you taking me back to my car? We passed it up. And it, at that point, hit her 2 times in the eye area. And then at some point made an abrupt turn without any sort of signaling into this dark area that had some woods. And the entire time she says she's panicky, she's nervous, she doesn't know what's going on, she doesn't know where they're going. And at that point, the level kind of rose because she's in this dark area. She says, I don't know what's going to happen. I think I'm going to be raped. I think I'm going to be killed. I have to do something to try to prevent this from happening to me. And at that point, she decided to work up the courage to open the door and jump out of the vehicle. She testified, she landed on her shoulder, she felt pain at that point, she was trying to get herself up, she kept on looking back, saw he was still kind of moving forward, but at some point she saw his reverse lights come on, he reversed back and did hit her in the shoulder. I can't remember exactly if it was the same shoulder or not, but in one of her shoulders. She was able to somehow get herself over to a house, was screaming, hitting the house, trying to get somebody's attention for help. She ended up going to another house, realized that one was vacant, went back to the same house, and only after that, the person in the house called the police, and that's when they came. At that point, Mr. Jarvis was in fact gone.
Now, as Mr. Jarvis has indicated in his brief, it sounds as if the victim had numerous iterations of what happened. There was some fairly serious conflicts in her testimony from a factual perspective. Would you agree with that?
I wouldn't agree with that. The victim at first stated that the strikes, because the dispute was when the strikes happened in the vehicle. That was the inconsistency out of all the rest of her testimony. There was no dispute, or in my review of the testimony, that seemed to be the limited issue of the discrepancy. And she at first said it happened before she exited the vehicle the first time, and then upon some further clarification with the state, she said, no, actually that took place after I re-entered the vehicle. And she said it had been several years since the incident occurred, and that was her confusion, was that time lapse between the actual events and her testimony there. So I wouldn't say that there was several iterations of her testimony, several changes. It was the timing of those hits that took place within the vehicle.
But the degree of the injury to the eye was clear and not disputed.
No, the evidence with regard to the injuries to her eye were actually, I believe, in the medical records, because her medical records were actually placed into evidence. And I don't actually remember any dispute as to those injuries at all, or even to the fact that she had a fracture in her collarbone, because that was also contained within the medical records.
I thought I read in the brief that the officer who responded did not see, or said that he did not see any bruising, and also that there was an internal dispute in the medical records as to whether there was a fracture. Initially, the medical records did not establish that there was a fracture, but later the doctor testified that he disagreed with that and thought that that was an error, that there wasn't a fracture.
Sorry, Your Honor. My understanding was that, in fact, there was some sort of x-ray taken initially when she first went to the hospital, and that there might not have been some sort of finding with regard to the fracture, but that, in fact, the doctor then came back and looked at it again and said, no, in fact, there was a fracture there, that there was an error in that initial reading of those x-rays.
The wet read, I think.
Yes, Your Honor, exactly, the wet read of the x-ray. Correct. So the medical records did in fact establish that, as well as Miss Anderson herself testifying to the fact of the fracture and the results of that after the fact, and that she had pain for months thereafter, that she had difficulty for 6 months after even fastening her bra, was unable to wear a bra for 6 months because of that. And she still had consequences of those injuries to the day of her testimony, in that she had difficulty when she would pick up her children, like actually lift her children, as well as in her job, because she was a hairdresser, and stated that at some points, because of the pain and injuries that she sustained as a result of this incident, that she couldn't even finish some of her clients as she was going through. So the state would submit that Jackson's actions
You mean
Jarvis's actions, I apologize, thank you, Your Honor. Jarvis's actions was exactly what caused the injuries here, because but for his actions, Miss Anderson would not have had to jump out of the car of that vehicle to try to escape whatever fate may have been if she had not. And therefore, there was in fact sufficient evidence not only for the substantial risk of serious harm in regard to the kidnapping counts, but also with regard to the serious physical harm in the felonious assault counts. And with regard to the manifest weight argument, in addition to Ms. Anderson's testimony, there was also testimony of the detective that interviewed Jarvis, and he stated that there were 2 interviews with Jarvis, and in that second interview, he did in fact admit that he hit Ms. Anderson while she was in the vehicle, that she was not free to leave the vehicle, that he in fact she did jump out of his vehicle, and that after the fact he did hit her with his vehicle. All of that corroborated the testimony of Ms. Anderson. And I know there was some issue with regard to the EMT versus the officer, the initial responding officer, with regard to Ms. Anderson's level of inebriation. The EMT stated that she can smell some alcohol, and that she would not have wanted her to drive home at that point, whereas the officer stated that he did not smell any alcohol on her, and that she did not seem intoxicated at that point. And in just reading further into the testimony of the EMT, she also stated that the reaction that those actions that Ms. Anderson was displaying at that time could also be attributed to the fact that she was just through this traumatic event. That those same type of characteristics could be displayed as a result of just having to jump out of a vehicle and risk of your life, and possibly anything else that could have occurred if she had not. Therefore, the state would submit that the convictions in this matter should be upheld, and his assignments of error be overruled. Any further questions? Thank you, Your Honors.
Have to.
Very briefly. I just wanted to point out, as the court is aware, the medical records were submitted. There wasn't testimony from the doctors at the hospital, and sort of explaining that sort of narrative of what may or may not have happened in there. You'll see the medical records in the record. The medical professional testified was the EMT on scene, but obviously did not do the subsequent paperwork from the hospital. I'd like to just point out that in the kidnapping statute, if the circumstances of this case are held to be this was sufficient to meet that under the B section, there's 2 parts to the kidnapping statute. In Part A, it requires some purpose, that you're going to kidnap someone for a sexualized purpose, or for money, to a government official. And in the B section, it requires this second part. It's clear that the state chose to proceed under the B section and not the A section in this regard. So, does every time a kidnapping occurs, where someone is someone in a car with someone, does that always create a substantial risk of serious physical harm? I mean, and I guess that's what I want to look at here, and I hope you look at that. That's really, while the facts are unsavory for Mr. Jarvis, I'm arguing that he committed something, but it doesn't meet this level. And I would argue it's more akin to an unlawful restraint and a simple assault, or maybe some other offenses that the state could have thought. But I don't think it reaches this level. I ask that you consider that, and I don't think that the facts here arise to him knowingly doing exactly that. And while I know it is unsavory to look at what happened here from that perspective, it is not hit and arise to the level of a very, very serious charge of kidnapping and felonious assault, because he could not have anticipated those consequences as a natural result of what he did.
How do you square that with the court's decision in State versus Brownlee that said the injuries suffered by a victim while escaping from a car can be considered in determining whether the victim suffered serious physical harm?
What happens in the differentiation between this case and that case is that while I know the court stated that those things couldn't possibly be considered, this is a situation where she reacted on. I'm trying to phrase this in a way that doesn't sound bad, because it's tough to phrase this situation that way. Is that she jumped out. She jumped out in a way where the car could have stopped. The car could have been things that could have been. She made the situation almost worse than it could have been.
I'm afraid you're.
Thank you. Thank you.
Thank you. We will take the case under advisement and send you a copy of the written decision when it is issued, and you can find it on the webpage as well.